Good afternoon, everyone. My name is Teela Waller, and I'm an associate at Michael Lynch Family Lawyers. Thank you for joining me for today's webinar, which will cover confidentiality and counselling in family court matters. Just a bit about Michael Lynch Family Lawyers before we start. As many of you know, we are a team of specialist family lawyers, and the firm was established about 27 years ago now. We have over 100 years of combined professional experience. We see private clients and provide confidential and professional advice in all areas of family law. For new clients, we offer the fixed cost and obligation-free consultation to provide the client with the initial critical advice about their situation so they know how to navigate their family law matter. We have many flyers and articles which are available on our website, which I know many of you use. Counsellors can provide these to their clients, which is really helpful. So today I will touch on a number of things, including family dispute resolution and family counselling. This is as it is defined under the Family Law Act. I'll also cover confidentiality and admissibility. This is about counselling notes and what happens to those notes in family law proceedings. Also, when you might be asked to provide evidence in court proceedings, whether that is written or oral evidence in a trial. I will talk about parenting arrangements and the terminology used as well. Counsellors often come across parenting orders which use some legalese and different language. I'll finally talk about children's wishes and how that is involved in proceedings. So, what is family dispute resolution? I'm sure some of you are either family dispute resolution practitioners, or you may have heard clients or other people talk about family dispute resolution, or FDR as it is abbreviated. For your reference, you'll see on the slides we refer to FLA. This just means the Family Law Act. So family dispute resolution is a process where the practitioner assists parties to resolve the issues around separation, divorce, parenting matters, and child support potentially. FDR practitioners must be accredited to facilitate the FDR conference and undertake certain training. With parenting matters, it's compulsory to attend, or at least attempt to attend, an FDR session prior to commencing court proceedings. You will receive a Section 60I certificate which says whether the parties attended, whether one party tried to attend and the other party refused, or whether it was not appropriate for FDR at all. The usual exception for this is, or when it may not be appropriate to do FDR, is if there's domestic violence involved, because that has other issues involved. Parties may also be able to get an exemption from doing that FDR process if there's some kind of urgency involved in the matter or some other really serious issue that the court needs to address more quickly. We've also got family counselling, which is defined separately in the Family Law Act. It is the process in which a family counsellor helps parties or children with issues relating to the marriage, separation, or the parenting arrangements. This is also defined in the Act, and again, the person that is providing that service has to be authorised under the Family Law Act to do so. There is a link on the slides which can be provided to you, which includes a list of counselling organisations who are authorised in this relevant section of the Family Law Act. This list is different to other professionals who might just be providing private counselling to people and are engaged privately by those clients. So, do you have to tell a client what the Family Law Act says? If you fall into one of those very specific categories of family counsellor advisors or family dispute resolution practitioners that I mentioned, the Family Law Act does provide a number of things that you are required to tell clients or parties coming to you for those services. Again, this isn't necessarily the same if you're just providing private counselling to someone outside those categories. An advisor is compelled to give advice to parents about the fact that they need to have regard to the child's best interests as a paramount consideration, encourage parties to be child-focused when they're making decisions, and using that best interest of the child principle while also having regard to any need to protect a child from physical or psychological harm. We'll go through those principles and where they lie in the Family Law Act when we talk more about parenting arrangements shortly. However, the advisor must also provide advice of the benefit of the child having a meaningful relationship with both of their parents. Under Section 63, capital D, capital A of the Family Law Act, you also need to inform parties that they can consider entering into a parenting plan and where they may be able to find more information about that process. Often what happens at an FDR session is if parties have been able to reach an agreement, they may decide to document that into a parenting plan. You have to tell clients about the parenting plan and that it should have regard to the child's best interests. If you are having a discussion about parenting plans, you must also inform the parents about the process that the court considers when determining what arrangements are in the child's best interests. I'll also go through that a bit further shortly. Parties will need to be informed that the court will consider equal time arrangements if it is in the child's best interest and reasonably practicable. If not, substantial and significant time between the child and the non-resident parent is considered with regard to those considerations. If this is not appropriate, then the court can consider any time arrangement that is in the child's best interest and reasonably practicable. If there are already court orders in place, you should be telling clients that if they do enter into a subsequent parenting plan, then that parenting plan can actually override the court order if there's any discrepancies. So it's important to tell people that before they enter into a parenting plan, just to make sure they're aware of what consequences that may have on any other court documents that they have, for example. You should also tell clients about the availability of services and other courses. There are many out there. There are lots of post-separation parenting courses, including Triple P parenting courses, post-separation parenting orders programs through Relationships Australia, just to name a few. These help with implementing court orders and assisting with disputes that may arise between parties. There are also many services provided by organisations such as Relationships Australia, as I mentioned, which you can inform clients about. As counsellors, you would know that you have certain notification obligations as well. This might be what you refer to as your mandatory reporting obligations, such as when a child has been abused or is at risk of abuse. These are referred to on the slides with the relevant sections of the legislation for you. You obviously have to comply with various Commonwealth or state legislation in relation to reporting that to police and child safety where necessary. Of course, anything we speak about today does not override your usual obligations to report those things that may come up. So the specific area I wanted to address today is what communications may be made during family counselling and family dispute resolution as they are defined in the Act and what we've just spoken about. Communications made during family counselling or FDR are confidential and inadmissible unless an exemption applies. You will notice in the Family Law Act there's a lot of areas where there's a general rule and then exemptions. Family law is certainly not black and white and there are grey areas. The general rule is confidential communications are inadmissible unless an exemption applies. And the sections of the Act do quite helpfully set out what those exemptions might be. They are listed on the slides and it might be worthwhile having a copy of those or looking at those if you do have these questions come up. The Act says that you must not disclose communication made in family counselling or FDR. In saying that, you must disclose to comply with your mandatory reporting obligations as mentioned earlier. You otherwise have a discretion to disclose the information in other situations. You may disclose the information if parties consent. The disclosure seems necessary to protect a child from harm, or you need to report an offence. You may also disclose if it would assist the Independent Children's Lawyer, or ICL, in the matter if one has been appointed by the court. You may not know that a judicial registrar, a senior judicial registrar, or a judge may appoint an ICL who's there to represent the child's best interests and act on their best interests. The ICL is not acting for either mum or dad. Confidentiality is different to admissibility. So confidentiality is whether your notes can be disclosed. Admissibility is how the court can use that information. This is a question that comes back to the parties' legal representatives and the court itself if they're involved in that kind of process. As I mentioned, communication during family counselling and FDR is not admissible unless an exemption applies, such as if there is abuse or risk of abuse under those sections of the legislation. There is some contradiction or conflict regarding what a family counsellor may decide to disclose under their discretion and what might be admissible in court. For example, even if you decide that you do want to disclose the information to assist the ICL, the parties and the judge may still have an argument about whether that information is admissible in the court proceedings. This isn't necessarily a matter for you as a counsellor to worry about though. Just to recap on what the legislation tells us. Evidence of things said with a family counsellor or practitioner during family counselling or FDR is not admissible. There are some exceptions to this, including if there's an admission by an adult of child abuse or if there's a discussion of child abuse. This is unless the court thinks there is sufficient other evidence of the admission or disclosure. This shows us that the court does want to protect that therapeutic relationship with the family counsellor. So if there is another way to receive the information, for example, if there's police records or school records of the child's major disclosures, child safety, for example, the court prefers that evidence to relying on notes from counsellors or in FDR. This system just gives people the confidence in FDR and counselling as a way to resolve a dispute without being concerned that that information is going to be used against them in court. There have been some cases that have been taken to the court where there's been some dispute around the application of some of those sections of the Act. There was a case by Uniting Care looking at this section 10 capital D about the issue of when a counsellor may disclose information. The court said that the discretion remains with the family counsellor as to whether to disclose that information, even if both parents consent and if the court directs. So just because the court says, I want that information, the sections of the legislation really say that that's ultimately up to the family counsellor, unless it's one of those mandatory exceptions. So again, even if the communication can be disclosed, it's not necessarily admissible, unless it's that kind of risk of abuse or that high-level risk scenario. Obviously, the court has to be conscious of breaching that therapeutic relationship, but obviously the need to protect children is really at the forefront of the court's mind. So if there is a need to protect children from that, they need the information they can to make a decision about those things. There was another case, which was the Baden-Clay case. I'm sure a lot of people have heard about that case. These sections only relate to the family law jurisdiction. Sometimes we see matters like this where there's cases of domestic violence or other civil cases. That case involved domestic violence, as many of you know, and therefore our sections of the Act don't necessarily extend to cases like that and other civil cases as well. It's really a case-by-case decision when it comes to confidentiality and admissibility. Therefore, it's important to get particular advice if you are faced with one of these issues about whether the notes should be disclosed, as there are different rules that operate in different areas. As I mentioned before, at a family dispute resolution conference, often the outcome may be that the parties agree to a parenting plan, and we'll talk a bit more about a parenting plan later on. A parenting plan that is achieved at an FDR is not confidential because the parties need to rely on that parenting plan to show the court what they've agreed and what the arrangements are to make sure that everyone's on the same page. Parties might need to provide that information to a school, for example, so that's not confidential. If parties reach an agreement and don't document it into a parenting plan as such, it is still not confidential. There's no strict format for a parenting plan, but if it's written signed, dated by the parties, and has been made without duress, then that means it's a parenting plan and it's not confidential. If it's just a verbal agreement that they've reached, then that can't be disclosed in the court proceedings, similar to the content of FDR. It is not admissible as evidence either. This is because the whole purpose of an FDR is to have a confidential space for parties to be able to have a discussion and try to resolve these issues. In relation to family counselling, again, as I mentioned, that section really defines that as a specific class of accredited counsellors, and the list is on the Attorney General's website. It doesn't just mean any counselling, it has to be counselling directed to the parent's relationship and breakdown. So it's not about a different category to family therapy or that private therapy for one parent. The big questions that may come up for counsellors is how they may be required to give evidence and when they are compelled to give that, as opposed to when it may be voluntary. There's a couple of ways this may come up. You may be served with a subpoena, which requires you to produce, for example, a copy of your notes. You may be subpoenaed to actually show up at court and give oral evidence. You may be asked either directly by the parents or from a family law solicitor or some other person involved in the matter to give a report. This would then be attached to an affidavit to be signed by you, which would usually include your CV, your resume, or something like that to show your qualifications. The reason for this is that the party is relying on you as an expert in that area. The things I'm speaking about apply for both family law and domestic violence proceedings. It is important to keep in mind that if you receive a subpoena, a court has made that subpoena and it is compelling you to provide the requested information or present at court. There are some very serious consequences if you fail to comply with subpoena without a reason. Usually subpoenas to counsellors request certain documents on your file about a certain person or a child, and they usually give their date of birth. There may be a specific list of things that they're asking for. You can ask for conduct money, which is money to comply with that subpoena, because there may be staff involved in collating that information and photocopying and providing it to the court. If you are required to actually appear in person, the same applies. You may ask for conduct money because you may not be at work for an entire day, for example. As I mentioned, there are serious penalties if you don't comply with subpoena. However, there are situations where you can object to compliance. There's really strict time limits in place, however, so you should review the subpoena quickly and seek legal advice if you don't intend on complying with the subpoena. You should note down the production date for the information and the date the objection needs to be filed. This will ensure parties and the court know what you're planning to do. There's quite limited grounds that you can actually object to a subpoena. For example, it may be that the material is irrelevant to the parenting proceedings, or it's a very broad subpoena, which makes it hard to narrow down what you're needing to provide. There's always amendments being made to the subpoena rules, so you should keep an eye on that as well. Generally, in parenting matters, parties will be subpoenaing a counsellor for notes about either the parent's sessions or the child's sessions, including when they've gone, what sessions have been cancelled, and then notes about what happened during the session and any communications between a parent and the counsellor or the office, for example. The other situation you may be asked to provide information is by directly a parent or a lawyer, where they ask you to provide a diagnosis and report about the client you've been seeing. This is voluntary and you're not required to comply with that request at all. You should be mindful that if you agree to prepare a report to assist negotiations, for example, you may be required to attend a final hearing and be cross-examined at that hearing about your views and how you came to your conclusions. A big thing that is related to counselling notes and being subpoenaed to provide notes or appear in court is notes in relation to victims of sexual assault or alleged sexual assault. There is Queensland legislation which was enacted on the 1st of December 2017, which protects records regarding those issues. This covers domestic violence proceedings as well, and there is a particular pro bono service called the Counselling Rights Protect Service, which give advice about that. If you have notes around sexual assault, being a victim of sexual assault, for example, there may be a further exemption as it relates to criminal and civil court proceedings, and you can contact that service to get advice about that specifically. In the context of this state-based legislation, counselling is given quite a broad definition. It refers to counselling in the sense of providing advice and encouragement and help to someone, as opposed to needing to be any kind of specifically registered list of counsellors. Those counselling records are protected from being able to be provided in court or from being subpoenaed. Again, the legislation only covers those matters from the 1st of December 2017 onwards, and that's not the same as family law exemptions that we spoke about earlier. So that's more generally for the state-based legislation, which is criminal and civil, including domestic violence, rather than the federal legislation, which covers the family court side of things. It is another area, again, where there are grey areas, so there's a lot of different exemptions. So I have covered the general evidence-based issues that come up for counsellors. I now want to talk about the parenting arrangements themselves and how they may arise for counsellors generally. Just to cover off what the legislation says about those things and the terminology that you may see coming across. Parenting arrangements can generally come about in 3 different ways, including verbal agreements between parents, where they've just said, let's do this and we'll see how it goes, or they may change it week to week. The second way is for a parenting plan to be signed, which is a written document signed by both parties, as I mentioned earlier. It doesn't need to be a specific format necessarily, but that's often what comes out of an FDR session. The third way is the consent orders or court orders. So verbal agreements are usually in place where parties are fairly amicable after separation. Sometimes children have high needs or there are other issues going on with the family that makes it too difficult to formally document an arrangement after separation. Parties often work with a verbal agreement until they can get something more formal. For this to work, parents generally need to have quite a high level of communication because they really need to be able to talk regularly about what's happening for the children. We know this can be really hard for clients, particularly so soon after separation. The parties who can make it work are often not the people we see as family lawyers because often they have gone away and done their own thing without needing that legal advice. So a parenting plan is where the care arrangements are put into the written document, signed and dated by everyone without either party being under that duress. As I mentioned earlier, there's no particular format to it. The parenting plan can be quite flexible because it's not a court document. There isn't really any restrictions on what can be included in that document, and there's not necessarily any jurisdictional issues with what can be included, such as child support orders. It can cover off on a range of things, and it really can be tailored to what the children need. There is a minimal cost involved if the parties can sit down and prepare it themselves. Otherwise, parties can seek the assistance of lawyers or the mediator at an FDR session to assist them. A parenting plan is not binding and enforceable. This is perhaps a downfall of a parenting plan, depending on the particular clients. So for example, if parties are high conflict and unlikely to comply with the parenting plan, there are no ramifications if it is breached. However, the parenting plan can be used as evidence of what the intention was at the time and what those parties at the time thought was best for the kids. In summary, a parenting plan provides a level of formality and a reference document for parties to look back on. It can be used if parties want to trial an arrangement post-separation before documenting it in a binding consent order. However, if you have a very high conflict parents, or if there are significant issues with their parenting arrangements, then it may not be the best option for them in the long term. So of course, the third way to document parenting arrangements or where they may come up is in a court order. Parties will give copies of orders to counsellors and medical practitioners to show what was agreed and/or approved by the court. There are two ways you can receive a court order, either by agreement, which is what we call a consent order. You will see at the top of a consent order, it would say something like, "It is ordered by consent on a final basis." This order is made differently to an order imposed by the court after a contested final hearing of the matter, where the judge hears all evidence and makes a decision for the parties. Parents can negotiate consent orders between themselves or with the help of a solicitor. The format of a consent order is more formal than a parenting plan, as it is filed with the court, and the court needs to be able to enforce those orders. Once the parents receive a sealed order back from the court with a stamp at the bottom, it's enforceable. Once an order is made, it can only be changed if parties agree down the track and consent to that, or if they go back to the court and ask the court to make it. In that sense, a consent order is less flexible than a parenting plan because technically a consent order is in place until children turn 18. Parents can make an application to the court to change a consent order or a court order if they can demonstrate that there has been a material change in circumstances since the orders were made, which was not contemplated at the time the orders were made. This is quite a difficult threshold to overcome. It might be, for example, when there are significant drug or alcohol misuse issues which arise, which were not evident at the same time the orders were made, for example. Parental responsibility is something that you've probably seen if you do come across a lot of court orders or parenting plans. Parental responsibility is the decision-making responsibility for parents, which relates to those major long-term decisions such as education, health, religion, living arrangements, which would make it significantly more difficult for the other parent to see a child, and also the child's name. Without an order in place, the legislation says that parents have joint parental responsibility. When looking at what the court considers when determining a parenting matter, they start with the presumption that parents have equal shared parental responsibility. This presumption can be rebutted if there's issues of family violence and when it's not in the child's best interests for the parents to share those responsibilities. So again, parental responsibility relates to the decision-making power and not the time or custody as it was previously called. So equal shared parental responsibility doesn't mean equal time. This is a common confusion for clients. Parents will have the day-to-day decision-making power for children while they're in their care. This refers to decisions like what they'll wear, if they go to their friend's house, etc. While this is something that we would confirm with our clients, these are things that you could flag with them if they are becoming confused. So once the court considers parental responsibility, they consider the parenting arrangements. Firstly, the paramount principle and the paramount consideration for the court when they're looking at a parenting matter is what is in the child's best interest. You'll hear this term over and over again. There are many matters that inform the court's decision, including primary and additional considerations. These considerations are set out in Section 60cc of the Family Law Act. This is quite a good section for you to look at as well when speaking with clients. Now, we often hear clients say something like, "My child is now 13 and he can make a decision," or "My child doesn't want to spend time with the other parent." If a client says that, you can say to them that there are many other considerations that are taken into account in addition to a child's views, which depend on their age and maturity level and understanding. So that's the general framework that the court uses when they're making a decision about a parenting arrangement. And again, it's all about directing people to be best interests and child focused when they're looking at what arrangements are appropriate. So the two primary considerations are the benefit to the child of having a meaningful relationship with both of their parents. Again, you will see there is an overarching consideration of any need to protect the child from physical or psychological harm and family violence. This is the second consideration, but it does take priority. If it may not be a benefit to the child to spend time with the other parent, for example, if there's serious risk issues, the court will take that into account. As I mentioned, there are additional considerations and they are set out in section 60cc of the Act. Some of those include the views expressed by the child or the children, taking into account the child's maturity and understanding. Secondly, the nature of the child's relationship with each of their parents and any other extended family. The extent that each parent has taken previously to participate in decision-making, spending time and communicating with the child. The likely effect of any change in circumstance for the child, including separation from a parent or relative. And of course, any practical difficulties of spending time and communicating and the expense of that. There are some other considerations which include the parent's capacity to provide for a child's emotional needs, the maturity, sex, lifestyle and background of the child and the parents that may be relevant. There's a particular consideration given if a child is Aboriginal or Torres Strait Islander and making sure that they have a connection to their culture. If there's been any family violence, the court looks at those orders and what the circumstances of those orders were and how that evidence may be needed to be considered in the parenting discussion. Whether an order should be made that will be least likely to lead to further proceedings is important. The court doesn't want parties to keep coming back, so they make sure the orders, as much as possible, won't lead to further litigation. There is also any other fact or circumstance, so the court has quite a broad discretion to look at whatever matters they think might be important and relevant. Now that we've considered the paramount principle, the primary and additional considerations, we now look at the different parenting arrangements you may see in a parenting plan or a consent order. The document would set out who the child's to live with, spend time with, speak with on the phone or via FaceTime, etc. The wording of a typical order where the mother is the primary carer would be something like, unless otherwise agreed in writing between the parties, the children will live with the mother and spend time with the father as follows. The provision would then set out the different days and times that the children spend with the father. It could be alternate weekends, a night during the week, 5 nights per fortnight, etc. As long as the order clearly sets out the days and times for changeovers. As I mentioned earlier, we don't use the word custody anymore. We use a live with and spend time with type of terminology. The orders usually also include time during school holidays and special occasions, such as Christmas, Easter, Father's Day, Mother's Day, and overseas travel and passports. There are many other issues that can be included in an order, such as a high school that the children will go to if they haven't reached that age yet, if there are step siblings, birthdays to consider, etc. The order can go as far as prohibiting parents from relocating outside a certain kilometre radius of a CBD, prohibiting a parent from consuming alcohol or illicit drugs, etc. So, of course, it's ideal for parents to agree on these things because parents know the children far better than lawyers, the family report writer, or the court. All we and the court can do is look at the evidence that we have and try to work out what's in the child's best interests. This is why we say that court is definitely a last resort for parties. So in terms of how the court may decide what time arrangements is in the child's best interests, if the presumption of equal shared parental responsibility applies, the court must consider if equal time is reasonably practicable and in the child's best interest, as I mentioned earlier. Reasonably practicable looks at how far apart the parents are living, where the kids go to school, where the parents are working, who can do pickups and drop-offs, etc. If that's not appropriate or in the child's best interests, looking at all of those considerations that we spoke about, we start looking at significant and substantial time and whether that's best for the child and whether it's reasonably practicable as well. Substantial and significant time generally means that the parent who doesn't have the child for the majority of the time is having time on both weekends and weekdays, holiday time, and time on special occasions. If that's not practical, or if that's not best for the child, then the court has that discretion to make whatever orders they think are in the child's best interests. This is something that is called less than substantial and significant time, which is, for example, alternate weekends. You probably won't see the wording equal time or substantial and significant time in an order, but you will consider the criteria that makes up those phrases to see what it actually means. As I just mentioned, there are these factors to look at when deciding what is reasonably practicable for the children. And at the end of the day, it's all about the children and not the parents. The court isn't too concerned about making things easier for the parents, and it's all about the children's best interests. Something lawyers hear a lot, and you probably as counsellors hear a lot as well, is this question: when does my child get to decide where they live? In short, there's no set age under the legislation when a child can say where they want to live. Often we hear this myth that it's 12 or 13 when children can decide. This section of the Act really just says it's one of the factors to be taken into account, and even then, it depends on a child's maturity, how firm their wishes are, and how they're expressing those wishes and how it's come about, really. I wanted to just touch on the International Convention on the Rights of the Child as the foundation for children's wishes. So the older and more mature child is, and a reason why they're expressing those wishes will help the court to place more weight on those views. It is very different if you've got a 5-year-old saying, I want to live with dad, and when you look into it, it's probably because dad will have a PlayStation and mum doesn't. This is very different to a 13 or 14-year-old who's expressing a wish, and they may have other reasons for doing that. A very mature 10-year-old may be given more weight than a more immature, perhaps, child who's older or who may have learning difficulties or something, and the child doesn't have the maturity or understanding to make that call. This is another reason the court assesses matters on a case-by-case basis. It can create quite big problems if people have said to their children that when you get to your 12th birthday, for example, you're going to be able to make that decision. So it's just something to be mindful of if you're having those discussions with clients as well. So while children have views and their views are considered, it is not something they can usually voice directly to the court. This is something that can create problems in a matter. So we have certain ways of conveying a child's wishes. The first way is for a parent, grandparent, or someone else like that to put in their affidavit evidence about what they heard directly from a child. Judges can speak to children directly, but it's very, very rare in Australia. So I haven't actually ever heard it come up in a matter before. I have had a colleague say that she was in the back of a courtroom and the judge asked to speak to the child, but they were 16. It would really depend on the case and the child's maturity and understanding, as I said earlier. Another way is by an application of a child seeking to become a party, but again, this is quite rare as well. An independent children's lawyer can speak to children. We spoke earlier about ICLs, which are solicitors who act for the child's best interests and not necessarily the child. Occasionally they speak to children depending on their age. The more independent and more commonly known way we would usually get evidence of a child's wishes before the court is by doing a written report. The family consultant preparing the report can give oral evidence about their report and their findings. So, as I said, the weight to be attached to a child's wishes depends on their age, maturity, and understanding. It is just one of those Section 60cc factors, and the court will consider how strong that wish is, whether there's a rational basis for them having that, or whether it's being influenced or coached by a parent or some other person. Also, what impact will it have on the child if their wishes are followed or if they're not followed? For example, if you have a 15-year-old saying, I want to live with dad, We consider what's the impact going to be on that child and on their self-determination and ability to make those decisions moving forward if it's not followed by the court. Parents hopefully aren't telling their kids that they're able to make the decision at some point. Again, it is assessed on a case-by-case basis. Just a little bit about the court process and what happens if you are involved in court proceedings or if you've got clients involved in court proceedings. To begin the process, one parent or grandparent generally files an initiating application along with an affidavit which sets out their kind of version of events and what they want the court to do. There are some other supporting documents, including a genuine step certificate and a notice of child abuse, family violence or risk document, which notifies the court if there's any urgent domestic violence or risk issues. If parties aren't seeking interim parenting orders, they don't necessarily need to file an affidavit. However, they will need to file a parenting questionnaire. This is a form which was created around the time of the court merger on the 1st September 2021. So prior to filing, there are pre-action procedures that people need to follow. The court prepared a brochure which can be downloaded on the court website. It's showing that the court really has a focus on parties trying to resolve matters through dispute resolution and without the intervention of the court. We spoke earlier about the Section 60I certificate that parties receive from an FDR practitioner. Parties need to have attempted FDR unless one of the exemptions apply. Once you receive that Section 60I certificate, you need to write to the other side, whether they're represented or unrepresented, and say to them, what are the issues in dispute? What is your genuine offer? What orders will you seek if the matter goes to court? And what the time frame for a response is, which needs to be at least 14 days. The client may receive a reply to their notice. However, if they don't, or an agreement can't be reached, they can commence proceedings with those documents that we just spoke about. The other parent will file their response to the first party's application, setting out their version of events and responses. The respondent has 28 days to file their response documents. The first court event will usually be listed within 1 to 2 months of filing. The court event is very procedural and the registrar can't make decisions about time and only what is agreed or procedural, like a family report or an ICL appointment. The matter will follow the court pathway through potentially multiple court events and another FDR if it's appropriate. If an issue is urgent, such as the children's school or parties can't agree on interim time arrangements, there will be an interim hearing listed before a senior judicial registrar, like a judge, who can make that decision. The matter may get to a final hearing within 12 months of filing, however, it can drag out further depending on the court's capacity. About 90 to 95% of matters resolve at some stage along the court pathway, and the statistics are often changing. Parties might be assisted by a child impact report prepared early on, which is a short form family report focusing on particular issues. Otherwise, a private family report can be prepared by a social worker or psychologist who speaks with the parties and the children, if it's appropriate, to work out what is in the children's best interests. There are many opportunities throughout the court pathway to resolve the matter, and parties are continuously encouraged to do so, given the delays, cost, and emotional toll that the court process takes on parties. I could chat to you all day about the court process and the different variables that arise for each matter, but the key takeaway on this process is that we always encourage parties to resolve matters if possible. However, that court process is available if an agreement can't be reached at all. I wanted to provide a summary of what we've discussed today and some tips for counsellors and FDR practitioners who come across these issues. In terms of counselling and notes, it's not confidential. You should work on the basis that if you are subpoenaed, you would be required to produce those notes and documents. When you're looking at note keeping and what you're keeping on your files, think about what the purpose of your note keeping is. Perhaps avoid making general comments or opinions when you're writing notes, and instead really document the facts. What did they tell you? What dates did they come to see you? Know who contacted you with the appointment, all of those sorts of things. The interpretation of confidentiality and admissibility, as we spoke about, is still quite unclear. There are other provisions in the Family Law Act, but there's also a lot of exemptions and different definitions of things. There is no clear-cut yes or no answer as to whether the notes will be admissible in court. I would just assume your notes can be subpoenaed and assume that you can be compelled to give oral evidence, and seek advice from your own professional bodies about note-keeping and responding to subpoenas. If you receive a subpoena, you must respond to that in some way, whether it's objecting or whether it's asking for more information. So don't just ignore it, because there are court documents and there are penalties if you're not complying with them. I would encourage practitioners who are having these family law issues, even if things are amicable between the parents, to be getting advice from a family lawyer in private practice. There are some amazing community legal centres in Brisbane as well who provide a one-off legal advice for a limited amount of time. This can really help clients get on the right track. Otherwise, parties could contact Legal Aid Queensland to see if they are eligible for legal aid funding. Thank you all for joining me for today's webinar. We've covered a lot surrounding confidentiality, admissibility, and the court process generally as it relates to parenting matters. As many of you are aware, we deal with many areas of family law which are set out on this slide. This area of law is very broad, and many areas such as parenting and property go hand in hand. If you do have any questions, please send them through to our email address on this slide. Otherwise, we will send around a feedback survey after the webinar, which you can use to specify any questions or comments about today's webinar. We do really appreciate the feedback that you have for us. As I mentioned earlier, the court has a very useful website and resources available for parties and practitioners, including some videos. If you have any suggestions of any topics that you would like to see covered in future webinars, please reach out to us as well. Again, thank you for joining me for today's webinar, and I hope you've enjoyed it.